Hey guys, it's Roxann Smithers with Smithers and Ume-Nwagbo, and we are here with part 2 of our 3-part series on When You're Right, tips to win a dispute without going to court. So we've already discussed documentation, and now we're on to tip 2, which is motivation. And what this means is really understanding both your position in a dispute as well as the position of the other party in the dispute in order to help you come up with a strategy to resolve. One of the first things that you want to think about are your goals for the relationship and your goals for the dispute, as well as the other party's potential goals for the relationship and for the dispute. For example, if you are in a dispute with a long-term customer or a long-term supplier, and you know this is a relationship that you want to continue, that is going to impact the approach that you take in trying to resolve the dispute. You may be willing to take a little less than you would take from someone else. You may be willing to give a little more than you would give to someone else for the sake of the relationship. And you often give someone a more of a benefit of the doubt with regards to their version of the facts than you might if it's not a long-term relationship. On the other hand, if you're in a dispute with someone, then it's a one-off business connection or business exchange, and that's not really a concern, you may take a more aggressive approach in resolving that dispute, and you may be willing to accept, you may push for higher amounts for resolution or give less for that resolution because you don't have this other goal in terms of maintaining the relationship. Speaking of goals, you also want to understand your business goals, and often understanding and having some insight into the other party's business goals can impact how you resolve a dispute. For example, if the entity that you're dealing with is a representative for a property owner or for another person and they're in a contract chain, they may be motivated to try to resolve something quickly so that they don't have an issue with their upstream customer. This happens often in construction contracts where a general contractor is obligated to maintain a clear title on the property that they're working on. For a lower tier sub, that gives you leverage. We'll discuss the power of liens and bond claims at another time. Another business goal that you might have is managing your cash flow. Understanding that you might need a dispute to resolve quickly if you're looking for payment so that you can keep your cash flow in line. Or understanding that you may want a situation where you pay out on a dispute over a long period of time because you want to protect your cash flow. So understanding your business goals as well as your opponent's business goals can help you in understanding the best strategy to resolve that dispute. Speaking of strategy in resolving a dispute, you might also want to check your calendar. As I've found in handling business issues both in the courtroom and outside of the courtroom, the time of year can often matter greatly in the amount it takes to resolve an issue or what a party is willing to accept. We've often found both with small businesses or executives or individuals that people are more willing to resolve a dispute if they are accepting payment around the holidays or birthdays, because everyone likes a little extra cash in their pocket around those times. Consider your opponent's business calendar, consider their production calendar, consider when their funds are moving out of their business very quickly. Those things can impact when they're willing to resolve and how much they're willing to resolve a matter for. A next point that you want to think about are the costs that are involved in handling a dispute. Not only may it cost you funds in terms of legal costs, but also man hours and other resources to support a dispute. It's going to have a cost to your opponent as well. And so taking that into consideration based upon the value of your claim and what it may cost you to resolve your claim can help you think about the best way to resolve the dispute and impact your strategies as well. Because remember, both mediation, arbitration, and litigation have different timelines, but they all can cost tens of thousands of dollars depending on the type of dispute that you face and find yourself in. Finally, you want to look at the issue like a stranger. If you and your other party are not able to resolve internally your dispute, you're going to be looking to what are called disinterested third parties to look at the facts, look at your position, and decide who's right or wrong, or decide how a matter should be resolved. So you want to put yourself in the shoes of that stranger when you're looking at your claim and you're looking at your position in the dispute, and really think about how a third party might resolve it. You may see that they probably resolve it more favorably, or you may see that it's in your best interest to resolve it amongst yourselves. All of these tips fall under that category of motivation, understanding why you're in a dispute, why the other party's in the dispute, and what factors may impact their willingness to resolve and how they're willing to resolve. So this is Roxann Smithers with Smithers and Ume-Nwagbo, and this has been a note from my legal pad. To learn more about the attorneys with Smithers and Ume-Nwagbo, you can visit us on Facebook, LinkedIn, our YouTube channel, as well as stulawgroup.com.